Well, Stephen, thank you, sir, for joining us tonight for the Civil Rights Roundup.
Thank you for having me, Cam.
My pleasure. And tonight we're going to talk about a case out of Colorado, the campus in Colorado, right?
Right. It's called Students for Concealed Carry on Campus versus Regents of the University of Colorado et al. And here's what happened. In 2003, the Colorado legislature enacted the NRA-sponsored SB 0324 bill, also known as the Concealed Carry Act. And they did that in order to remedy inconsistencies among Colorado's various local jurisdictions regarding permits to carry concealed firearms, both the application process and then how permits are treated. And amongst many other things in the Concealed Carry Act, the Colorado General Assembly manifested a clear and unmistakable intent to subject all governmental entities to a statewide policy regarding a matter of statewide concern, namely governmental policy in regard to the carrying of concealed weapons. And Cam, at this point, let me quote a few passages from the finding section of the law, that make it absolutely clear what the Colorado legislature intended. And here's the statute, quote, "The General Assembly finds that, A, there exists a widespread inconsistency among jurisdictions within the state with regard to the issuance of permits to carry concealed handguns and identification of areas of the state where it is lawful to carry concealed handguns. B, this inconsistency among jurisdictions creates public uncertainty regarding the areas of the state in which it is lawful to carry concealed handguns. C, inconsistencies results in the arbitrary and capricious denial of permits to carry concealed handguns based on the jurisdiction of residence rather than the qualifications for obtaining a permit. D, the criteria and procedures for the lawful carrying of concealed handguns historically have been regulated by the state and should be consistent throughout the state to ensure the consistent implementation of state law. And E, it is necessary that the state occupy the field of regulation of the bearing of concealed handguns, since the issuance of concealed handgun permit is based on a person's constitutional right of self-protection. There is a prevailing state interest in ensuring that no citizen is arbitrarily denied a concealed carry permit and in ensuring that the laws controlling the use of the permit are consistent throughout the state," unquote. Well, Cam, by the way, that and more can be found in Colorado Revised Statute Annotated Section 18-12-201. And again, these are just the findings of the statute. But Cam, what it does, it makes clear that the Concealed Carry Act intended that there be statewide uniformity, and that there be statewide uniformity not just in regard to the application process, but also in regard to the policies for and any restrictions placed on the actual carrying of concealed firearms by permit holders. And again, it's absolutely clear what I just read. What they wanted was statewide uniformity, not just in regards to application procedure, but also in regards to permit holders and how they may carry, in the state. And like I said, what I quoted above are just the findings of the act, and I'll get into the specific provisions of the act in a minute. But first, let me talk a little bit about the case: Students for Concealed Carry on Campus versus Regents of the University of Colorado et al. And this case first arose because of a firearms ban that the University of Colorado had. And by the way, it needs to be noted at this point that the University of Colorado is a state school. It's not a private school.
Okay.
So the restrictions that govern state governments also restrict the University of Colorado. It's an arm of the state government. Well, here's the policy. In 1994, University of Colorado passed a very broad prohibition on concealed carry, on possession of firearms. And here's what they said. The policy, it banned, quote, "the possession of firearms, explosives, or other dangerous or illegal weapons on or within the University of Colorado campus, leased building, or area under the jurisdiction of the local campus police, or areas where such possession interferes with the learning and working environment," unquote. So it's a blanket ban on possession of firearms.
Okay.
And in this case, Students for Concealed Carry on Campus, also known as SCCC, is challenging the university's firearms ban on the grounds that the 2003 Concealed Carry Weapons Act, Concealed Carry Act, which I just quoted a moment ago, manifested a clear and unmistakable intent by the state of Colorado to subject all governmental entities to a statewide policy regarding matters relating to concealed carry. And on December 11, 2008, the SCCC filed suit against the University of Colorado on behalf against the university, and it challenged the university's firearms ban on the grounds that the ban violated, one, the Concealed Carry Act, which I just quoted,
right,
and two, that it violated the Colorado Constitution's right to keep and bear arms clause, which can be found in Article 2, Section 13 of the Colorado Constitution. And the case was filed in Colorado State Court, and the NRA Civil Rights Defense Fund has helped fund the case. And in their defense, the Board of Regents of the University of Colorado maintained that the university's ban does not conflict with the Concealed Carry Act. Even though they are a public university, they claim that they are not subject to the statute since they are not a local government, but rather an arm of the state government. But, Cam, this is a very weak argument. I mean, the Concealed Carry Act is clear in that it applies not only to local government, but also state governmental institutions, all sorts of state governmental institutions, including the University of Colorado.
Yeah.
And then,
the University of Colorado is trying to hold itself out as some sort of home rule powered agency that didn't fall under the purview of this?
Well, that's a good point. They did argue that in the case. They argued that under the Colorado statutes that create them, they're given the right to govern themselves. Well, that's correct. As the Court of Appeals, we're getting a little bit ahead of ourselves here, but in the court, as the Court of Appeals pointed out, yeah, you have the right to govern yourself. That doesn't mean you have the right to violate the laws of the state. I mean, if you take the Colorado University's argument to an extreme, what they actually said is we have the right to govern ourselves. The Concealed Carry Act does not mention us specifically, and therefore, we're exempt from the requirements of the act.
Mm-hmm.
Well, in that case, the University of Colorado could argue that they have the right to commit murder.
Right.
I mean, if you look at the Colorado state statute that prohibits murder, it probably doesn't specifically say, and this law applies to the University of Colorado also. It's just going to say it's illegal to murder someone or to speed or pick whatever you want to.
Yeah.
But the position of the University of Colorado is, hey, we have the right to rule ourselves. And true, it says so in the statute. And because of that, here's where they go, a little bit nuts. They go, because of that right to govern ourselves, we are not subject to any state law unless it specifically says the University of Colorado is included in this prohibition. So, technically under that argument, they can murder, they can kill, they can kidnap, whatever they want to, as long as the statute doesn't specifically say, and this law also applies to the University of Colorado, and that's kind of a crazy argument, and that's what the Court of Appeals also said.
Okay.
Now, the other thing is that you got to remember is that the Concealed Carry Act does have a specific list of exemptions. Where government can ban the carry of concealed firearms, and guess what? Public universities are not listed on that specific exemption, okay? The General Assembly did not list any public university when listing locations where concealed carry can be restricted.
Mm-hmm.
And let me quote the statute. Quote, a permit to carry concealed handgun authorized the permittee to carry concealed handgun in all areas of the state except as specifically limited in this section, unquote. And let me repeat that again, in all areas of the state except as specifically limited in this section, unquote. And the statute then lists a series of exceptions, some of which apply to local government, but also others including which clearly apply to state governments. I mean, for instance, a permittee may not use a handgun in a manner that would violate state law. Local government may not adopt or enforce ordinances that conflict with the Concealed Carry Act. And then police, state, and actually that's not one of the exceptions. Police, state, and local police can temporarily disarm a permittee incident to lawful stop or arrest of the permittee. A permittee may not carry concealed handgun into a place where the carrying of firearms is prohibited by federal law. And then here's an important one. Quote, a permit does not authorize a person to carry a concealed handgun onto the real property or into any improvement erected thereon of a public elementary, middle, junior high, or high school, unquote. Now, Cam, what you got to note here is this exception specifically says that a public elementary, middle, junior high, or high school you can't carry. But it specifically does not include universities, institutions of higher learning. So, in other words, the exception applies only through high school. And the Colorado legislature could have said and public colleges and universities, but it didn't say that. And there's another important exception. which prohibits carrying a concealed handgun into certain specific public buildings, and then it defines those public buildings, and this clearly includes state government buildings. This exception does, but it doesn't list public universities. And lastly, there's an exception which provides that, quote, a private property owner, private tenant, private employer, or private business entity, unquote, retains his property rights. But remember, Cam, the University of Colorado is not a private college. It's a state university. It's an arm of the state, so this exception doesn't apply either. Now, if the Colorado General Assembly had intended for the University of Colorado or any other public university to remain a place where concealed carry was not allowed, then the legislature could have easily stated, use the words public university right after the word public elementary, middle, junior, or high school in that exception about schools,
Right.
But they didn't, okay? And again, the Concealed Carry Act, which I quoted earlier, authorized licensed concealed carry holders in all areas of the state except those that are specifically accepted by the statute, which I just mentioned, which includes elementary, middle, junior high, or high school, but doesn't include university. And a public university was not specifically listed as an exception, so it can't be construed as a place that can ban concealed carry. Now, the Concealed Carry Act of 2003 makes it clear that the Colorado General Assembly meant for concealed carry to be a matter controlled by state government, so that local governments and state governmental entities could not interfere with the right to keep and bear arms in self-defense, which is guaranteed by the Colorado State Constitution. And what happened is on April 30, 2009, the Colorado District Court in El Paso County dismissed the case, okay? And the court, what it did, it used the very deferential rational basis test in dismissing the constitutional claim. Well, this lesser test simply requires that the legislation bear some reasonable relationship to a legitimate government interest. And the trial court said, look, the university's anti-gun policy declaration, where they say guns are bad, we don't like guns, guns cause crime. They said, well, they said it, and that reason supports the university's anti-gun rule. And then the district court simply held that the plaintiff state to fail a cause of action. I don't understand the opinion. It's a politically motivated opinion. Now, the dismissal was then appealed by the SEC, and the Colorado Court of Appeals did the right thing, reversed the decision of the district court unanimously on April 15th of this year. And the Court of Appeals pointed out that the job of a court is to, quote, effectuate the General Assembly's purposes intent, unquote, and that the Concealed Carry Act clearly intended to, quote, create uniform statewide standards concerning the carrying of concealed weapons, unquote. And the Court of Appeals pointed out all the arguments I made a moment ago, that made it clear that the university is not exempted from allowing concealed carry. And in regard to the university's arguments, including the one that you mentioned earlier, that they have home rule and therefore no laws apply to them.
Right.
Well, the Court of Appeals said this. Let me quote them, quote, we are not persuaded, unquote, end of sentence, okay? And the court held that the university's policy violated the Concealed Carry Act. And in regards to the plaintiff's constitutional claim, the Court of Appeals also reversed the district court's dismissal. Now, the court didn't get into the nitty-gritty of whether this violates Article 2, Section 13. What the Court of Appeals held is that the deferential rational basis test that was used by the trial court, that was not the appropriate test to use in reviewing a policy that impinges on the Colorado right to keep and bear arms, and that the more exacting Colorado reasonable exercise test, which has been previously used by the Colorado Supreme Court in gun rights cases, applied. And the Court of Appeals remanded the case for reinstatement of the plaintiff's claims and further proceedings consistent with the court's ruling. And then this summer, very recently, the regions narrowly voted to appeal the case to Colorado Supreme Court. So this is still going to go to the Supreme Court. But I don't see anything happening other than the Supreme Court affirming, the ruling of the Court of Appeals.
Right.
Now, I'd like to take just a minute to discuss the issue of guns on campus, okay?
All right.
The regents of the University of Colorado state that the university has certain values, okay? We have values.
Yeah.
And that guns just don't mix with their values, okay? But, if you take a look at what they're doing, what they're really saying is that they do not believe in individual liberty. That's their value. That they do not believe in constitutional rights. That's apparently their value. And instead, the regents believe that they themselves are above the law and that they can violate the state law. Look at what they did. They're clearly violating the state law. They're trying to deprive people of their constitutionally guaranteed rights. These are the values? Come on. And then the second question you got to ask yourself, what are the real facts about guns on campus? Do they really cause crime or do they deter crime? Well, Cam, I got some statistics for you that easily answer that question. including, statistics from the University of Colorado and schools that have not banned guns, okay?
Mm-hmm.
Now, the fact is, unfortunately, sometimes you have tragic crimes that are committed on campuses, and sometimes they even involve firearms. The majority of them don't, but sometimes they even involve firearms, such as the tragic incident that occurred at Virginia Tech a few years ago. But, you got to note that all the campus shootings have involved schools where gun prohibitionists have had their way. All the shootings occurred in so-called gun-free schools, okay? Schools that prohibited firearms on campus, even by students and professors that had gone through all the background checks, training requirements, etc., to obtain a concealed weapon permit. And once again, the police were not able to timely intervene. There was a University of Alabama shooting that took place literally next door to the campus police station, okay? And you got to ask yourself, if any of those students or faculty, that had a concealed carry permit, if they had been allowed to carry their firearm, if they had been able to defend themselves, whether the outcome may have been different. And, I got an answer for that too, Cam. A few years ago, an unstable student at the Appalachian Law School attacked students and staff with a firearm, okay?
Yep.
Now, widely reported in the press was that he was stopped by other students. But you know what the mainstream media did not report? What they didn't report, what they failed to state, was that the bad guy was stopped by another student who had a gun. Okay? Now, the unfortunate fact was that the school had a no guns on campus policy, as all these schools do where the shootings occur. Okay? And so the good student had to leave the school when the shooting started, run to his car off school grounds, get his gun, run back inside to confront the shooter. And once the good guy confronted the shooter, once a good guy with his gun confronted the shooter surrendered. But unfortunately, during that time period, where the good guy had to run back to off campus to his car, get the gun, run back on campus, the shooter had shot 6 students and faculty, 3 of whom later died.
Yeah.
Refusing to allow guns on campus makes those who might be able to defend themselves and prevent crime elsewhere easy prey for these criminals. And you got to ask yourself, what has actually happened at those institutions where the universities trusted its professors and students?
Well, I can tell you what's happened.
Well,
nothing's happened.
And not only has nothing happened, but something has happened that's good. Crime has decreased. Schools that have allowed the right to carry to extend to their campuses have experienced a decrease in on-campus crime. Every public university in Utah has allowed concealed carry on campus since 2006, and there have been zero, zilch, reported misfires, accidental shootings, gun crimes, or any other gun-related incidents reported. Blue Ridge Community College here in Virginia, has also allowed concealed carry on campus for several years with 0 complaints. Now, after Colorado passed its shall-issue law in 2003, Colorado State University, they did the right thing. They allowed handguns to be carried on campus.
Yep.
Okay, concealed handguns. And since then, the school's crime rate has, guess what?
Plummeted.
Declined.
Yeah.
In 2002, before they allowed guns on campus, 800 crimes were reported on campus.
And I think last year it was, down to 200? Right?
200.
Yeah.
I mean, we're talking about a quarter of the crimes.
I know.
From 800 to 200. A drop in crime of 75%.
Yeah, I know.
Now, most notably, sexual offenses dropped from 47 reported in 2002 to only 2 reported in 2008. From 47, when guns were illegal on campus, now you suddenly allow guns on campus, go down to 2. From 47 to 2. Rapists, bottom line is, the rapists now have to consider, hey, my victim might be armed.
Yep.
That's a different calculus than I know my victim is disarmed thanks to my school's anti-gun policy.
Absolutely.
Now, the local sheriff reports absolutely no problems from concealed carry permit holders on campus. Well, how does the University of Colorado stack up to this, which has banned guns on campus? Well, they've experienced a 30% increase in crime over the same 6-year period. So, at Colorado State, from 800 crimes, it drops to 200, to a quarter of what it was before when they allow guns on campus. In the same time period, University of Colorado crimes go up 37%. The argument that students and professors are too irresponsible to handle guns, it's the argument that the anti-gun folks make. Well, they make it not just about universities, students, and professors, they make it about all of us. But that argument fails when you consider the actual requirements for carrying a concealed weapon anywhere, including a college campus. A student, a professor, anyone who wants to get a concealed carry permit has to comply with the state permit requirement. And, they vary from state to state, but all have some age requirement, education, training requirements. and they're designed to prevent anyone with a history of criminal behavior from carrying a gun. There's a police background check. And if you think about it, if an individual has been deemed responsible enough to carry a firearm concealed in the rest of the world, then why shouldn't they be permitted to do so on campus? It doesn't make any sense.
Absolutely. Absolutely. Stefan, as always, sir, it's great talking to you, and I know we're going to talk again actually next week. Yeah, we'll be back from Albuquerque next week, so we'll have more next week for the Civil Rights Roundup.
We'll see you then.
All right. Thank you so much. Stephen Thomasini, Deputy General Counsel of the National Rifle Association, join us here tonight.